SIAC had held, departing from its previous case law dating back to Al-Jeddah against the Secretary of State for the Home Department, that Ms Begum should have been notified of the Secretary of State's intention to make a deprivation order against her and should have been given the opportunity to make representations. We hold that at least a main purpose, if not the main purpose, of Section 40, subsection 2 of the British Nationality Act 1981 is to protect the public from a threat to national security, which could be frustrated by a requirement to invite representations prior to a deprivation decision. Notifying a person abroad of an intention to remove their citizenship could enable that person to make a preemptive return to the United Kingdom and frustrate the purpose of the deprivation decision. Those deprived of their citizenship are afforded an appellate-level merits review of the deprivation decision through SIAC. This distinctive right to appeal and the risk of preemptive action are, in our judgment, compelling reasons to construe Section 40, subsection 5 of the British Nationality Act 1981 as excluding any right to prior consultation before a deprivation decision is made on national security grounds, as was held in Al-Jeddah. In our judgment, SIAC fell into error in concluding that Ms Begum was entitled to the opportunity to make representations before the Secretary of State took the deprivation decision. In any event, however, SIAC was correct to rule that it was immaterial that Ms Begum was not afforded the opportunity to make submissions prior to the deprivation decision. It was inevitable that the Secretary of State would have made the same decision, regardless of possible representations made by Ms Begum. Ground 5. The public sector equality duty. The deprivation decision was exempt from considerations of the public sector equality duty under Section 149 of the Equality Act 2010, pursuant to the exemption created by Section 192 of the same Act, as it concerned the safeguarding of national security. In this case, the public sector equality duty concerns were whether the exercise of deprivation powers disproportionately applied to British Muslims and/or impacted detrimentally upon the relations between members of Muslim communities and others. In our judgment, the national security exemption applies to any exercise of function or powers. As such, the deprivation decision was exempt from the duties that arose under Section 149. The exemption did not require the court to undertake a separate proportionality assessment. In any event, SIAC had been correct to find that the deprivation power was exercised in a proportionate manner. In conclusion, for these reasons, we unanimously dismiss the appeal. It could be argued that the decision in Ms Begum's case was harsh. It could also be argued that Ms Begum is the author of her own misfortune. But it is not for this court to agree or disagree with either point of view. Our only task is to assess whether the deprivation decision was unlawful. We have concluded it was not, and the appeal is dismissed.